This is Neon Galactic, Key TV's production of a UAP-related podcast out of Eureka, California. I'm James Falk, your host. Thanks for joining us. Today, I'm absolutely thrilled to be with Daniel Sheehan, a famous attorney, a sort of living piece of American history who's been involved in a number of transformative cases over the last few decades that have often pitted David versus Goliath. He has been a public advocate for the little man and has done a number of cases, including the Pentagon Papers, Silkwood. He was responsible in some ways for Iran-Contra. He's done a lot of work, and most recently, he's put his shoulder behind the efforts at UAP disclosure, representing Lue Elizondo, who, of course, has been sort of the folk hero of the whole movement, coming out of ATIP in 2017, leaking videos or facilitating some videos to get to the New York Times, which showed seemingly otherworldly objects in our skies. And since that time, he's been working hard with a number of other folks to try and get some reforms through government in order to get some of that information released. Thanks for joining us, Danny.
Terrific. Thanks, James. I appreciate the opportunity.
So, I mean, real quick, let's just sort of get a sense of where we are now. I understand that the 2024 fiscal year NDAA, the National Defense Authorization Act, which had the Schumer Amendment included in it originally, would have done a number of things that would have helped propel disclosure along. They included basically a law that would have established a committee that would have worked on disclosing information to the public long term. It would have given investigators subpoena power. And long story short, all of the teeth that were in that amendment got knocked out by what seemed to be special interests connected to the aerospace industry. But why don't you tell us about what you were hoping to see passed in the NDAA and where we are now, Denny?
Great. Thanks, James. Yes, what the history has been of this is that the United States Senate Intelligence Committee actually crafted a 64-page bill, which set forth an entire, thoroughly thought-through protocol, pursuant to which people inside the United States military, inside our intelligence agencies, inside aerospace industry corporations that were familiar with information about the UFO phenomenon could come forward and present this, which they were presenting to the AARO office, the All-Domain Anomaly Resolution Office. But a lot of the whistleblowers were not satisfied with that because it was under the exclusive control, AARO was under the exclusive control of the Defense Department and the intelligence community, who were the ones that have been hiding this information for decades. Yeah. So the whistleblowers continued to come to the Senate Intelligence Committee, who had the adequate clearances, and started presenting the information to them. And so the United States Senate drafted this, the Senate Intelligence Committee drafted this 64-page bill that set up an entire protocol. It created an independent agency that was a board, actually, a review board that would have subpoena power to extract from all 6 of the United States military services, all 18 of the United States intelligence agencies, all 32 United States Defense Department agencies, and all of the private military contractors, any and all information that they had pertaining to the UFO phenomenon. And they went into clear definition about what they were talking about. They were talking about UFOs, flying saucers. They were saying that it wasn't weather balloons and it wasn't, Chinese spy balloons, but it was talking about flying saucers, UFOs. And also all the information that they had about the non-human intelligence that people believe are operating these UFOs. It was very specific and quite graphic, actually. And this 64-page bill was passed unanimously in the United States Senate Intelligence Committee. All Republican senators, all Democratic senators, 17-0, it passed with all that detailed language, making clear what this was doing. It then passed the United States Senate by 89-11. and it was sent over to the House side. And then what happened is the Republican head of the House Intelligence Committee, Michael Turner, who comes from the 10th Congressional District in Ohio, which is the home base of Wright-Patterson Air Force Base, where the original crash debris from Roswell was actually taken, and the bodies were taken. That district also is the chief field office for one of the major aerospace corporations that's called Radiance Technologies, that has been attempting to utilize the UAP or UFO technology for a new weapon system that is housed there. And that he got Turner, the head of the Intelligence Committee on the House side, got the head of the Armed Services Committee, the Republican head of the Armed Services Committee in the House of Representatives, this fellow Michael Rogers, who is from the 2nd Congressional District in Alabama, which is the home district of the Redstone missile testing range for the United States Defense Department, and he joined in trying to knock out the enforcement provisions of the Senate bill. The Senate bill not only gave not only set up an independent board to review all this information, but it also gave them subpoena power to extract the information coercively, if necessary, out of these different agencies. And it also, very importantly, gave that committee, that board, the authority to exercise eminent domain, to reclaim custody of the actual UFO craft, some of which had been put into the possession of Lockheed Martin, for example, and Raytheon. And that they knew that the Radiant Technologies, that their home headquarters is right there in the 2nd Congressional District in Alabama, where the rocket range is.
Yeah.
So these two men enlisted the support of this new fellow, this guy Michael Johnson, who is the new sort of interim Speaker of the House. That they enlisted him. And then he reached out to Mitch McConnell over on the House side, the minority Republican head in the Senate, and got him on board to knock out the teeth from this bill that actually enforced them to do this. But what we did is, in countering that, we insisted upon getting language put into the National Defense Authorization Act, which would mandate the turning over of all of these documents and stuff to the National Archives.
So the information will still be amassed, basically.
They required that they have to give it over, but it didn't put any deadlines on it, and it didn't give any subpoena power to make them do it. But it did order them to do it for the very first time in history. And so the original 64-page bill from the Senate got stripped down to a 24-page bill over in the House. And it's absolutely true that there are a whole range of important, legitimate criticisms that can and should be made of the insufficiencies of this particular act that was approved by the House. But it does do a number of things that are extraordinarily important. Number one, the United States Congress does order these military services and intelligence agencies and Defense Department agencies and aerospace industry corporations to turn over the information to the National Archives. And it also allows the Senate Intelligence Committee people and House Intelligence Committee people too, if they want to, who have the adequate security clearances, to get access to that information. So
Can I ask you a question?
Yes.
Once it's in the National Archives, is it up to the archives to decide what goes public and what's not, or does it all stay classified according to original calls made by the Intelligence or Department of Defense?
Well, actually, it's interesting. Even in this bill, there are two provisions that provide for public disclosure of information that is put into the archives. Number one, it says anything that has been, any information or materials that have been obtained more than 25 years ago, prior to 1998, has to be disclosed to the public unless the president himself or herself specifically intervenes and says that he or she wants to postpone the public revelation of a particular piece of information.
So that stands. That stands in the bill that will be approved on the 21st. Okay,
that stands in the bill, and so that's extraordinarily important.
Huge. Yeah.
For people to understand, right? And so you don't want that to get swamped by all of the legitimate criticisms of the bill about the lack of subpoena power and the lack of the eminent domain power, et cetera. So that provision is in there. And it is the same, it still gives the authority to the president to postpone some particular piece of information going to the public. It's 25 years old or more. But that was also in the original Senate bill. So that's not a distinction, okay? Now, then there's a second trove of public information, that information from 1998 up until the present time, the agencies that possess that information can actually designate, if they choose to do so, a certain corpus of that information that can be made public. Now, the criticism is that it's in the hands of the very same agencies that have been keeping it secret for all this time. Yeah. And so that the expectations are not high. They'll put a lot of information into that category. And the problem is there's no centralized agency or board to overrule them when they say, no, we want this to be classified still, and we're not going to put it into the public disclosure domain, okay? Now, but very importantly, what this bill does do is it does assign ongoing legislative oversight authority over this process in the Senate Intelligence Committee, but also in the House Intelligence Committee, in the Senate Armed Services Committee, in the House Armed Services Committee, and the Senate Homeland Security Committee, that all of these, there's 6 different agencies or 6 different committees in Congress, in the House and Senate, each of which has oversight authority over making further amendments or proposing specific protocols to oversee this process. So very importantly, if, for example, the citizens were all to write to their congresspeople and senators saying, we want the United States Senate Intelligence Committee, for example, that had authored the original act, to take steps that enforce this, that exercise subpoena power, for example, on behalf of the Senate Intelligence Committee, to mandate that a certain piece of information about which they already know be turned over into the archives so that other people can see it, not the public to start with. But so the bottom line is that the effort that was made by the people that watered down the bill to kind of diffuse authority into 6 different committees usually results in nobody doing anything about it.
Yeah.
And so what we're proposing is that everybody who's listening to this podcast or this video, that what they do is write to their congresspeople and their senators insisting that the Congress undertake public hearings to ascertain what the potential insufficiencies of this bill are and promulgate some additional protocols that lend specific teeth to this thing. Now, people are going to argue that, well, the other side has already mobilized to strike those things out of the bill. So if you come back in, and what we're saying is if you focus on these things specifically, we may be able to mobilize enough citizen support to demand a specific tooth to this thing, or a certain set of teeth to this thing, that we then may be able to overcome the resistance.
How do you judge the receptivity of, say, the Senate Intelligence Committee to this at this point? Have you had any communications, or are they up to that?
Oh, yes. Oh, no. We've had regular communications with the Senate Intelligence Committee people and their staff, and with Senator Rubio, and with Mark Warner, and others, and with Gillibrand, Senator Gillibrand, and others. That they are upset over the fact that their more thoroughly thought through bill with actual enforcement authority and stuff was watered down. And so that we believe that they're disposed toward coming forward now with what we've already gotten and try to supplement that. And they have, under this bill, the legislative authority to do that, to propose that type of legislation. So the process has been delayed, that's for sure.
Yeah.
There was a full set of deadlines, for example, time deadlines in the Senate bill that have been taken out of the watered down bill. For example, there was a mandate that one mandate has survived, and that is that there's a 300-day period, basically a year after the passage of this bill, in which the agencies have been mandated to gather together all the information they have about UFOs and about the non-human intelligence behind them, to gather all that information together and make it available to the National Archives. That 300-day period remains the same. Now, the problem is that in the Senate bill, there was a 180-day period within which the public information that was going to be made public had to be made public. And in the stripped down bill, it just says as soon as practicable, or as soon as is reasonably possible. And those are, for lawyers, your hair stands on end.
Absolutely.
And you say, whoa, wait a second, that's you can drive a truck through that exception. So what the Senate has to do is have hearings to focus on some of these insufficiencies, draw public attention to those insufficiencies. We, as the New Paradigm Institute, that has been designated in the Senate bill to be one of the citizens groups that is going to be overseeing this process. What we need to do is help educate the American people and to educate them as to who their particular congressperson is. Many people don't pay much attention to that.
Yeah.
And they know who their senators are. But we try to mobilize the people, help educate the people about what these insufficiencies are in the present bill, and focus on the pieces that need to get amended or supplemented or strengthened, and then have them get back to their senators and congresspeople to insist that this be done. And that's what's going on right now. So that I give this stripped down bill, as I said, basically a 65. As a college professor and a law school professor, I grade students' papers, and I would give this like a 65. It's basically passing, but I'm not going to write a letter of recommendation to go to grad school, for the authors of this particular stripped down bill. But it's there, it's passing, and what we need to do is use it as a skeletal framework on which to put more and more muscle. Okay, and that's what we're in the process of doing right now at the New Paradigm Institute. So people can go to our website, and free. They can get a bunch of information about it. They can get a copy of the bill, so they don't have to spend all their time trying to dig it out of the 3,500-page National Defense Authorization Act. They can get a copy of this particular bill. They can also get a copy of the original bill from the Senate, which is extremely important because they can see that the entire United States Senate has basically agreed that this ought to be the law. Okay, so that you can take great solace from this and say, look, let's continue to conduct ourselves as though this is the way it should be.
Yeah.
So that we have specific guidelines on what it is that needs to be improved about the act, and yet you have the support of the United States Senate behind it already.
Real quick, correct me if I'm wrong. There's legislation that's been in place in previous or basically passed in previous NDAAs that had some requirements that, maybe I'm, just worried, but it seems like the U.S. Air Force hasn't completely complied with some of the requirements that were made in some of these previous NDAAs in terms of sharing information or helping their service members come forward. What if there is no mechanism for enforcement in there? Is that something that you're hoping like the Intelligence Committee would come back later and say, if you don't do this, then there will be consequences? That sort of thing, in addition to what you mentioned. Well,
the way to actually solve that is to actually subpoena them.
Yes.
That's what a subpoena is.
Sure.
Is that you specifically subpoena them, which is giving them the order that they have to, under the pains of punishment for contempt of Congress, if they don't comply. So the subpoena power, in a sense, codifies that entire process by means of which you notify them of what they have and what you want. And if they don't give it to you, that there's specific punishments that are already designated for contempt. Okay, so that's one of the specific things that we're talking about. Now, the previous bills that have been passed, what they did, for example, the statute back in 2023 that got put into, or 2022, they got put into the National Defense Authorization Act, created this office, this ARROW office, that are the initials for the All Domain Anomaly Resolution Office. And what that did is it entailed protection for whistleblowers. It said that anybody who's in possession of any information about UFOs or about this non-human intelligence that they believe to be behind the UFOs, that anybody who's in possession of it that are in the military or in the intelligence community or in the private sector that have signed national defense, non-disclosure agreements or have security clearances can bring their information, and they can set aside those non-disclosure agreements and set aside those security clearances and provide it to the ARROW office. Now, the problem is that while that very importantly gives protections to the people who have the information, it doesn't require that they do it. And it doesn't require that the agency of which they're a part do anything to facilitate them doing it.
Yeah.
What it does is it protects them against any type of recrimination. Okay. And the problem was that the potential whistleblowers didn't trust ARROW because it's under the control of the Defense Department and the intelligence community that are the active agents that have been concealing this all the time. So they had the sense that if they bring this information forward and give it to the ARROW office, it basically doesn't really go anywhere. It just tells the ARROW office that it's there. And the ARROW office has kind of limited mandates that have been put onto it to compile the information and make it available to the Congress in a classified appendix to their report, their annual report. And then they have a section where they can put information to the public if they choose to do so. But the problem was that the ARROW office was believed by the whistleblowers to still be under the aegis of the Defense Department and the intelligence community. So they didn't trust it. And so that it wasn't really proving to be very effective as a means of getting the information really brought forward and made available even to Congress. So this is a second bite at that very large apple. This bill that was passed by the Senate was the follow-up, saying, okay, we've set up an office where the whistleblowers can come and put out their information and codify it in a way that if, in fact, the ARROW office decides to reveal it to Congress, which they're required to do, then that is of some advantage. But they realized the insufficiency of this primarily because the whistleblowers kept coming to the Senate Intelligence Committee instead of the ARROW office, saying, we don't trust the ARROW office. We're going to come to you and we're going to give you this so you'll know what's going on here. And then the Senate Intelligence Committee staff used that knowledge that they had to create the new bill. And that was sort of the gold standard of that Senate bill. And so what we have now is we have not a gold standard. I'd say we have kind of a lead standard of the bill. A stripped down bill, I think, is a little more accurate, from 64 pages to 24 pages, and most of the enforcement mechanisms have been taken out. So that's putting it very simply. But very importantly, what it does is if you step back one step, you would say, well, wait a second, why would the United States Congress pass a bill ordering the Defense Department and the intelligence agencies to turn over all the information they have about UFOs and about any non-human intelligence connected to the UFOs, unless they had believed there were such documents?
Yeah, well, absolutely.
They wouldn't do that.
The same thing with the proposal of the bill to begin with. I mean, all the language that was in that was sort of a soft affirmation that at least some of these ideas are not nonsensical.
That's right. They're much softer than the Senate bill. For example, in the Senate bill, there were specific findings.
Yeah.
They put specific findings in part of the 40 pages that were taken out. They said the United States Senate or the United States Congress hereby officially finds that there is credible evidence to believe that the intelligence agencies and military services and Defense Department agencies and aerospace corporations are in fact in possession of knowledge and documentation pertaining to the UFO issue and pertaining to the non-human intelligence. And so it makes that finding. Now that finding has been taken out of the bill. And so that you have to go by inference by saying, why would they pass a 24-page bill even, ordering them to turn over information about this if they didn't have reason to believe that they had the documents, And so it makes it a little more difficult for those of us in the public interest community to say specifically that now the United States government has officially acknowledged that they've got these documents, So we're trying to be as responsible as we possibly can be, while still not, drinking the Kool-Aid, of the House Intelligence Committee that doesn't want to say those things. Because we know from talking to the Senate Intelligence Committee people, we know what they've got.
Yeah.
So we know that they've got the documents, and we know what the documents are talking about. And so that we have to conduct ourselves responsibly as people's advocates, telling the people that we know that they've got the documents.
Yeah.
And now Congress, even both the House and the Senate, have ordered them to turn over whatever, if anything, you have, to turn it over. And so that's what the new bill does. And that is very significant.
Yeah.
Very significant, despite the legitimate criticisms, significant criticisms that have been made about the stripped down bill.
Now, so the way you describe the process, it sounds like the Senate Intelligence Committee is sitting on a treasure trove of testimony from a lot of different whistleblowers. Do you have any idea of the breadth or the contents of that? I mean, I know obviously it's classified, but
yes.
Can you share that with us at all?
Well, what they have is David Grush has testified to the House Oversight Committee, their subcommittee on national security, on July 26th. He testified that he has read the documents, he has talked to the whistleblowers, and what they're saying is that our United States Defense Department and intelligence agencies and a certain number of aerospace industries are in possession of an extraterrestrial non-human spacecraft.
Yeah.
That's what he said.
He's saying now that he's been read in also, that he has direct.
Right.
Yeah.
That's right. And he has said that, they're also in possession of direct biological evidence of a non-human intelligence that is directly connected to the UFO craft. So he has said that. And so when you take his testimony and then you put it up with the bill that's just been passed, you can have at least that sworn testimony of a person that was the representative from the National Reconnaissance Office to the top secret UFO study program inside the Pentagon, telling you what is in the documents.
Yeah.
Okay.
Now, it seems to me that if we get a lot more momentum on this issue, if there were some affirmative, basically confirmation from someone in power, whether it's the Intelligence Committee or someone further up, that there is a non-human intelligence behind some of this. Now, I mean, so is there no way for members of the Senate Intelligence Committee to communicate that absent this huge infrastructure of legislation? Because once that admission is made and people are like, well, there's actually something out there, then the whole game's going to change. It's like people's minds are going to be blown and they're going to be skeptical for whatever, good or bad reasons, and they're going to want to investigate more, and that's going to blow the doors off the whole thing. But it seems like that admission is what they're fighting hardest to prevent. Do we have to go through all this legislative rigmarole to get to that admission?
The short answer is no, we don't. Now, but the reality is that inside Washington, what's going on is the attempt to construct a coalition of all of the elements of power that obtain in our culture to come to this extraordinary moment of actually revealing this, and so that there's this process going on where you have you have a dozen different committees of Congress. You have different intelligence agencies. You have different Defense Department agencies, et cetera, to say nothing about very powerful aerospace private corporations, all who have an interest in this. And so what they're trying to do is to find some sort of accommodation among all of these elements of power to bring the American public in on this secret. Okay.
Mm-hmm.
And so they're saying that because if it's going to, quote, blow your mind, there's a lot of people who think that blowing the collective mind of our American public probably isn't a good idea because people who had their mind blown, don't function very rationally. And so that what they're all trying to do is to come to not go to the lowest common denominator of who's going to ultimately agree to cough this information up, but to figure out some sort of a consensus that says the moment has arrived, and now we need to do this. Now there have been a number of occasions in the past, which you've probably heard about, where this issue has been put inside the government. Look at in light of all the information we have now, in light of how important it is, has the moment arrived yet where we need to do this or we ought to do this? And they've come together, and they've, in fact, Hal Puthoff, who is one of the major consultants to our government on these issues, has publicly now related the event that took place back, I think, in 2004, when a number of people were called to a meeting in Washington, and the question was put to them: what do you think the pluses and minuses are about publicly revealing the fact that we're in possession of a non-human extraterrestrial spacecraft and the biological proof of the existence of a non-human, highly intelligent, highly technologically developed species? What are the pluses and minuses? And that what happened is he said he recognized people that were in the meeting, major military officials, major intelligence people from the CIA and other places. So this was quite an authoritative group that gathered together, and they surprised themselves by discovering that the negatives considerably outweighed, in their mind at least, the positives at that point. So they're basically saying to themselves, what advantage do we get by bringing all the people in on this? They're not really going to be involved in making a lot of the decisions. Why should we do this? And what are the downsides? And so that we know from that open testimony of Hal Puthoff that very question was visited as recently as 2004. Now that's 20 years ago.
Yeah.
So the question is, why is it that, for example, David Grush was authorized
exactly right
by the United States Defense Department, a pre-publication group, to testify the way he did?
Yeah.
Why did they approve that?
Mixed signals we're getting, right? I mean, there's like mixed signals coming from government. Yeah.
That's right. And so why is it that Lue Elizondo and Chris Mellon were both cleared to make public the videos that they did, that they brought to the New York Times, and so that something is going on between now and 2024 that has caused the policy to migrate.
Yeah.
I guess we could say. But the reality is both Lue Elizondo and Chris Mellon had their security clearances challenged when they did that, after they'd already been authorized by the government to do that. And so there's still elements inside the Defense Department and intelligence agency, and certainly inside the private aerospace industry, that not only, it isn't that they didn't get the memo, it's that they read the memo and they don't agree with it.
Yeah.
So
one of the things that you said, sorry, go ahead.
No, so they're defying it,
Yeah.
So there's still a dynamic going on. And one of the problems is that I don't think public policy can accept decisions being made by the lowest common denominator, of whoever all the interest groups are, or else we'll never get progress on virtually anything. But on the other hand, there are arguments that are made that if you have the most forward-leaning, most aggressive, most radical people, who are proposing certain things that don't take into consideration adequately all of the potential negative repercussions of something, because they don't consider that part of their responsibility.
Yeah.
You can't have them being the ones to make this decision.
Someone has to be concerned about what the fallout's going to be.
That's right. And
Yeah.
so that there needs to be might not have to be absolute consensus, because otherwise the lowest common denominator then wins.
Yeah.
But there has to be some sort of a process of majority control, majority decision-making authority here, and public policy decisions that need to get made. And this is one of the very most important, because it's going to generate an entire new era of human history. Once our whole human family come to grips with the reality that there is in fact an extraterrestrial civilization of highly intelligent and highly technologically developed but distinctly non-human species in our galaxy. But the fact is, they're coming here. They're coming here in UFO spacecraft, and that we know that, and that we've recovered actual biological proof that such a species exists. And so that when that gets fully communicated effectively to the institutions of not only our government, but the entire geopolitical structure of our planet, there's going to have to be profound changes. Profound changes are going to have to take place. And the people that are in charge of authority on the planet are reluctant to have those changes made, because they believe that it's going to alter their degree of control over things.
Yeah, and they don't know where it's going to settle out. And they don't like situations where they can't predict with precision
That's right.
what's going to be unfolding from day to day. You said something in your last interview with Tim Ventura that I thought was really interesting about Radiance technology and the global quick strike program, and that they wanted to wait for disclosure to get a little bit more time to try and use that technology in order to develop a bomb that could deploy to anywhere in the world with, I think, 2 minutes, he said.
Wasn't exactly what I said. I'll be more precise about what I did say. But
go ahead.
Yeah, what's happening is Radiance technology is one of the aerospace industries that is at issue here. They've been in negotiations with Lockheed Martin to get Lockheed Martin to turn over one of the craft that Lockheed Martin have, so that Radiant Technologies can do research on a specific project, which is called Prompt Global Strike.
Okay.
And that is the attempt to develop a more than hypersonic missile that can house multiple U.S. nuclear warheads and can deliver from launch in the United States to Russia or China inside of 2 minutes. A massive nuclear strike, obviously a first strike, and that's what they're working on. And they're trying to use the UFO technology, which defies gravity, defies friction, and is able to travel at like Mach 25, to deliver a first strike weapon like that. And it's a real bad idea. It's a real bad idea. Now, people who are inside that defense industry, where they're trying to make as much money as they possibly can on weapons that are as lethal as they can possibly be, and enable our government military to maintain, in their own language, continued privileged access to the strategic raw materials needed by our industry. They view that as their mission. That's a problem.
Yeah. That's
a problem, because of what we have is, at the Jesuit headquarters, we used to refer to that as a sinful structure. Because if you have and it was just like Henry Kissinger said to us at Harvard College there in 1966, in Gov 182. He said to us, that if anyone in this class believes that our United States government is not authorized to lie, cheat, steal, and kill, on behalf of our own narrow self-interest, you shouldn't remain in this class. So, I was kind of taken aback by that because I didn't really think that that was what I was there to try to figure out how to do. But that mission has been assigned structurally to our United States military, and the Central Intelligence Agency believes that they are uniquely tasked with achieving that, and so that's a sinful structure. And so that people that are inside that structure don't experience it as sinful. They don't experience it as being completely inappropriate and in a structural way to lead to almost the inevitable destruction of our entire human species. But it does. And so that the bottom line is you can't allow people inside that group to be making ultimate decisions about what to do with this technology.
Because they have a very narrow slice of the national interest in mind.
That's right. And so that, under our democratic form of government, at least the Congress has to be making those decisions. It might not be under our representative democracy system. It isn't that there has to be a plebiscite taken of every single person in the country, to see what the collective desire is. But it's a representative democracy. And so therefore, our Congress needs to be the entity that makes that decision. And so they need to have the information. They need to know what it is that narrow element inside the national security state wants to do with the technology, and that they've got the technology and that they're attempting to do it. And they have been read out of that process. And so it's completely undemocratic. It's completely unconstitutional for the executive branch. And we already established that in the Iran-Contra case. When you have Congress in the United States pass a resolution, the Boland Amendment, in March of 1984, prohibiting the executive branch from engaging in delivering weapons to the Contras down in Central America, and then the CIA covertly attempts to get around it. That's unconstitutional. And the special prosecutor, Lawrence Walsh, in the Iran-Contra case, said that, and indicted them for having done that. And so that we have laws on the books right now, and we have a constitution that have to be obeyed if we're going to be able to maintain a democracy here. And that's what's at stake with this law. One of the most important and most profound realities is being concealed from the Congress of the United States, whom we as citizens have delegated the authority to make decisions on behalf of our body politic. And it's totally unconstitutional what's happening here. So as a constitutional scholar and the co-founder of the Harvard Civil Rights Law Review, I'm just here to tell you and to tell the people, this is profoundly unconstitutional, what's going on. And the Congress of the United States has to stand up and protect us, and enforce the Constitution. And so the good thing about this bill is they've at least said it. They've at least said that they're ordering these agencies to turn over the information to the archives so that the members of the intelligence committees, at least, can get to see it. So that's the way the structure is set up right now. All we're trying to do is get the citizens to make sure that it works.
What struck me, also everything you said was fascinating. What struck me about the use or the desire on the part of Radiance Technologies to get access to a UFO through, I guess, Lockheed in order to back engineer it. That makes it sound like they're close to successfully back engineering it. I know that we're in this global race right now with Russia and China with hypersonic missiles, and in a lot of ways we've been outrun by their technologies. And if we are looking to that and to be a sort of our trump card, that makes me think sort of more near term than what we've heard in the past, which is that's so far off that we haven't made any progress at all, so it's just been sitting in a warehouse or whatever. And then if that is actually the case, then the issue of disclosure becomes that much more transformative and necessary, because given the energy crisis and everything else, the technology we can find there could potentially revolutionize how we structure our grid and everything else. It seems to put a fine point on the need for this information to come out public now before it gets, used only for deadly purposes.
Well, at least to get our Congress to know about it.
Yes.
Yeah, that's why I keep emphasizing, is that the opponents are using the fear of having it just thrown out into the public, as revealing it to our enemies, as if we've got enemies, like we're like declared war with anybody, like with Russia and China, we haven't, but they consider them their adversaries, their competitors, and that isn't what the issue is here at all. The issue is whether it's going to be turned over to Congress so that they can make decisions in a representative democracy.
And that's the constitutional point that you're making, that without oversight, then we're outside of the constitutional regulatory structure, and therefore it's criminal.
We've become a national security state, and it's an authoritarian, non-democratic, military state. And we can't allow that to happen. And so we've been now faced frontally with this. And very importantly, we have probably the largest single constituency in the entire country supporting getting this information to Congress so that we can be protected and allow them to decide what it is they're going to share with our American people, right? So that we're at that stage now where we have to mobilize this constituency. That almost half of all the people in the country are supportive of the right of women to determine their own pregnancies, et cetera. It's a big, huge constituency.
Yeah,
it's a huge constituency in favor of equal rights for everybody. It's not a totality in the country. We still have problems in that area. But this may be the largest single constituency in the entire country.
Yeah.
So that what we have to do is mobilize that constituency, bring it to focus on the Congress, and therefore compel the Congress of the United States to exercise its constitutional responsibility to get this information turned over to them. And so far, they've taken the step of only telling the defense industry, et cetera, that they've got to give them the information, but they backed away from putting teeth in it.
Yeah.
And so they're still going through a process of, well, let's see how much they're going to voluntarily turn over to us. The fact of the matter is we already know how little they're going to voluntarily turn over to us because they've already concealed it for 75 years.
Now, can I ask you a question about legal process? If this doesn't work, and I think that you've mentioned before that legal action is a possibility in order to kind of force some of this stuff to come out. What does that look like in terms of timeline? If people are thinking that, well, let's do that instead right away rather than engaging in this process, that's not something that happens overnight, right? That would be like years and years down the road, because the process moves from court to court, and then it moves into the federal courts and Supreme Court and appeals, and it would be almost endless.
Well, the best example we have is what I mentioned, the Iran-Contra case, where we succeeded in getting Congress to at least stand up to the point where they would order the executive branch and the Central Intelligence Agency and the United States military to not provide any weapons, direct or indirect, to the Contras, because they'd been declared to be international outlaws, right? And so we got them to do that. But they declined to put any teeth into it, any enforceability into it. So what we did as the Romero Institute, the Christic Institute at that time we put together a federal criminal racketeering act, a civil lawsuit, and said that, assuming as we do what the facts are here, in light of the fact that we've conducted major preliminary investigations of this whole thing, we are willing to put forward in a federal criminal racketeering act complaint what the criminal operation is that's going on here and what's unconstitutional about it, and bring it to court. Now, of course, we ran right into the very issue you're talking about. The CIA and everybody started obfuscating and lying and getting the judge to back off and not really enforce our subpoenas and stuff like that. But what we were doing at the same time is we were going public with the information that we had, already. And so that's what caused them to have to hold major public hearings about it, because they realized that more and more of the American people were being read in on what was really going on, and that Congress was not exercising its constitutional responsibility to put teeth in that Boland Amendment and do something about it. So that what we have to do is try to figure out what is the analogous process that needs to be followed here. There's no doubt in my mind that this is a federal criminal racketeering enterprise that's going on. Same people are kind of involved in it. The Central Intelligence Agency's operations directorate, the covert operations people.
As we've learned recently.
There's a secret team functioning, whether you call it MJ12 or whatever its progeny is, that just like the off-the-shelf enterprise that we identified in that particular litigation. So I don't have any doubt that there is a federal criminal racketeering enterprise that's functioning that would be subject to such a lawsuit. But what we're trying to do here is we're trying to get the Congress to do it, because we know that the Senate Intelligence Committee and a vast majority of the senators in the Senate have already said what they want done, and we view that as adequate and sufficient to exercise their constitutional authority. So we have the complaint basically in place, and so what we've got to do is get that to be enforced, and so that what we're demanding right now, we're getting set to send out a call to action from the New Paradigm Institute, telling people that they can go to our website at newparadigminstitute.org, and you can see what who your Congress people are, get their emails, and you just push the button and it'll send the message to them that you want public hearings on this. Now that this most important law has been passed, what we want to do is have public hearings as to how effectively it's going to be enforced. So that's what we're doing right now. That's what we've chosen to do, because we believe that the exigencies of the moment are, as you have suggested, that it appears that they have now made some breakthroughs in actually back engineering some of this technology, where they're bringing it to bear in a weapons system that they're getting set to deploy. And they're going to try to roll out the old saw that, the Russians are going to get ahead of us, or, the Chinese are going to get ahead of us, et cetera. But the fact of the matter is, our government, we know from the 1992 United States Defense Department Policy Planning Guidance document that they view their mission as establishing full spectrum dominance over the planet. And that they believe that the objective is to establish and to maintain our continued privileged access to the strategic raw materials of the planet. That is a death trip, because if we're doing that, there is definitely going to be someone else, another nation state is going to try to do that, because they do not want to be completely vanquished. They do not want to have full spectrum dominance asserted over them, because they know that the objective of the full spectrum dominance is to get privileged access compared to them to the strategic raw materials that they're after.
And so it's basically supremacy for the long term, and who's going to accept that?
It's a declaration of war, and so what they try to say is, we can be trusted, but the Russians can't be trusted, and the Chinese can't be trusted. And what they do is they mount a full-scale propaganda campaign to try to convince the American people that these people can't be trusted. Whereas, we have direct experience after experience after experience that shows that the national security state people can't be trusted. That they invade South Vietnam, and they lie to us about the Bay of Tonkin resolution. They lie to us about what the whole purposes are of the war in Vietnam. And that's why I also was one of the attorneys for the New York Times in the Pentagon Papers case that revealed 47 volumes of detailed information showing that the national security state people were lying about the whole thing in Vietnam, that it was a military invasion, a unilateral, aggressive military invasion of the Southeast Asia by the United States military, and they were driven out of there. And the same thing is true of the invasion in Iraq. They're lying to us, and the Congress of the United States has to stand up and take back into its control the control over not only our foreign policy, but they've got to get control over this technology, and they've got to make it available, and they've got to have a treaty in which the United States is willing to lay down any claim to gaining superiority over any other nation state by the use of this technology in developing weapons. And they've got to get the other countries, China and Russia and India and others, to agree that they're not going to use this for military purposes. And they're going to have to destroy any of the weapon systems that have already been developed. Just like what John F. Kennedy was attempting to get Khrushchev and he were making the agreement to start destroying nuclear warheads. Not just building fewer more of them every year in the strategic arms limitation talks, but to actually start disassembling the actual warheads themselves.
Look what happened to John F. Kennedy.
Yeah, well, that's
exactly
right.
Yeah.
That's exactly right. And that's why these people are trying to be careful here, that they don't want to inspire the criminal elements inside the Central Intelligence Agency to start undertaking criminal action against the elected representatives, which they already did back in 1980. The Central Intelligence Agency's Covert Operations Directorate ousted Frank Church by putting millions and millions of dollars of drug money from Southeast Asia through the Nugan Bank in Australia into 2 South African banks into the United States. Millions of dollars they put into the campaign in Idaho in 1980 to knock off Senator Frank Church.
Because of the Church Committee hearings, right?
The Church Committee hearing, and they knocked off also got thrown out of office Dick Clark from Iowa because he opposed their covert operations in Africa, and they knocked off Birch Bayh in Indiana. This is absolute, total criminal, unconstitutional conduct on the part of the national security state apparatus. And so we've got to stand up in this case because they're threatening the destruction of the entire human family here. And they're threatening the basic relationship that we're going to be having with an extraterrestrial civilization for 10,000 years.
Yeah. And they're keeping from the American people fundamental knowledge about the nature of what is, which is like, I mean, it seems like it's a violation of human rights, basic dignity to know that if the government knows what's real in the world and then won't reveal that to people, they're basically helping to manufacture a reality that ensures their continued power. And
that's right. So this is a moment when the American citizens have to be adequately informed, because otherwise they're just totally losing confidence in the entire government structures. That's what we see happening. Yeah. An entire 2 generations coming up behind us in the baby boom generation that basically don't trust any of the government officials at all, don't want to participate in the election process, don't trust them, And the fact of the matter is, our generation, the baby boom generation, that helped lead the basic challenge to the simple blind faith in everything that our government told us, we need to realize that we have to do more than just undermine the absolute blind trust in government. We need to now start constructing grounds on which the new generations can trust the government. And we need to do it in this particular case because we have the largest constituency available that we're ever going to have on almost any issue. Everybody may not have been totally distressed about the fact that the Reagan-Bush administration was illegally smuggling weapons to the Contras, because that's kind of an esoteric issue. This is not. This is the largest constituency in the history of our American democracy. And so we need to bring it to bear, not only to get access to the information about the UFOs and the extraterrestrial civilization, but to start to disassemble the structural sources of injustice that are represented by the national security state. Yeah. That we've got to do that these people are willing to threaten the entire history of our human family for their own short-term gain, not only militarily, but for profit in the aerospace industry. I mean, that's the situation that we're confronted with here.
Yeah. Well, that's our time. That was amazing. Thank you, Mr. Sheehan. I appreciate you.
Terrific. I appreciate you, James. That's good. It's good to get an opportunity to talk directly to the people.
Yeah, yeah, and I will. I'll reach out to you again, I'm sure, in the future as this unfolds. Sure. It's a privilege to be able to talk to you, and I admire the work that you're doing. So thank you so much.
I appreciate that.
Okay.
So just have everybody get a hold of us at the newparadigminstitute.org.
I will. I'll put a link in the description and a link on the screen when we run the story.
Terrific.
All right, sir. Thank you very much. Bye-bye.
Terrific.